Mr. Hicks, nice to meet you.
Your name?
Brad Merrill with Attorney General's Office.
Nice to meet you, Brad. I noticed you and the judge walking in together. Were there any ex parte communications?
You know what the ex parte communication was, Mr. Hicks? That I had to wait for him to walk in the door so the deputy could walk us back here.
Just ask you a question.
Yeah, well, I've seen how you ask questions, and I did not like the intent of that question.
I think it's a fair question.
I don't think it is. Not from what I've seen of your actions so far.
Do you think you're objective on this matter?
I think I'm totally objective.
Okay.
I'm more objective than you.
Okay.
Yes. Mr. McDowell, nice to meet you. Well, driving down here, it's I was happy to see it was easy to find.
White County Municipal Court is now in session. The Honorable Judge Sundermann presiding.
Be seated, please.
You're on the record, sir.
Okay, we're here on a couple of motions. First one is the one by Mr. Hicks.
Sorry, Your Honor, we didn't bring it.
All right. Who's representing Mr. Hicks? You are, sir? All right. What would you like to say on... I've read the motion. Anything else you want to add?
Well, I want to make a statement about the affidavit itself. So,
Come up to the microphone, please.
Your Honor, this process has been unfortunately marked with bias and a lack of objectivity. On July 22nd, I filed a private citizen affidavit of 7 exhibits.
Yeah, I'm familiar with the case. You don't have to go over everything.
I'd like to make my statement if I could, Your Honor.
Make it brief, please.
7 exhibits, including an audio recording from an investigation that you ordered, an audio interview of Troy Bushman, Linda Fraley's stepson, which is Exhibit 6 and incorporated in my affidavit. That interview shows clear probable cause, while at the same time showing the bias and lack of objectivity seen in this effort. You have a duty here to determine if the low bar of probable cause has been met. Listening to that audio will clearly show that ORC 102.03d was violated when Linda Fraley sat one-on-one with Troy Bushman for reviews while married to his father, while he saw her as his stepmother, and while she made detailed review comments on his forms. I asked for that evidence, the audio, to be played here. I asked that once it is, that a complaint be issued and criminal proceedings be commenced. Others here want to make it about me, about anything but the 4 corners of the affidavit I submitted, and about anything but that audio and the probable cause it shows. You ordered an investigation, and on February 12, 2019, Agent Kevin Cooper first interviewed Chuck Tilbury, who was Linda Fraley's chief deputy. I submitted that as Exhibit 9 after seeing that Mr. Tilbury had been subpoenaed. I'm prepared to go through a timeline on that audio, but for now it is important to know that at 18:10 in that audio, Agent Cooper says to Tilbury that we want to get this over and done with within a month. That was before Cooper interviewed Troy Bushman later that day, and it was 7 days before Linda Fraley, who did not submit to an interview, submitted an affidavit. So how did Agent Cooper, and whoever the we was, know when things would be wrapped up? Exhibit 6 in my affidavit, the audio, is from February 12, 2019, of Troy Bushman's interview. Should be played here so we can hear what it says. Your Honor, if it is played here and we listen, we will hear at 12:30 that Miss Fraley and Troy sat together alone doing his performance evaluations. we will hear at 1540 that unlike other deputy auditors, Troy did not sit with his own employees for reviews. Miss Fraley did. We'll hear that at 1640 that the handwritten detailed notes on the review, on one review, which is Exhibit 4, are in Miss Fraley's handwriting. At 1925, we will hear the notes read aloud. They are detailed, precise, and not at all perfunctory. At 2115, we will hear Troy say that he considered himself to be her stepson. At 2255, we will hear that Troy says his 2014 termination goes, quote unquote, deeper than what Miss Fraley has said, that it is due to issues with him and Miss Fraley after his dad died. At 2322, we will hear Troy say that Miss Fraley fired him because of a family probate fight over his dad's stuff, and that Linda wanted to get rid of him now that his dad was gone. At 2340, we will hear Troy was not offered a position in the BMV after Miss Fraley gave it up. He has never worked in a BMV since. He never worked in a BMV before. And finally, Your Honor, if we listen to the audio, at 2435, we will actually hear Agent Kevin Cooper himself describe the relationship between Linda and Troy as typical stepson, stepmother. Your Honor, this review that I showed before, Exhibit 4, with her handwritten review notes and done while she was married to Troy's father, was enough for probable cause. The audio reinforces it in spades. She played a key role in his reviews. There was a familial relationship. It is clear probable cause. But consider, it was all based on exhibits I found and provided. Having heard about the one-on-one reviews, did Agent Cooper make the slightest effort to dig deeper? No. Did he use his subpoena power to get more copies of reviews? No. In fact, when you listen to the audio, you hear a man that every time Troy mentions what would be a crime actually changes the subject and leads the subject away from hazard or answers for him. And when Ms. Fraley submitted an affidavit on February 19th, 7 days after the interviews, did it contain any questions about participation in Troy's reviews? No. Was there follow-up given Troy's comments? No. In fact, several of her answers were in direct conflict with Troy's statements. For example, question: Is it standard procedure for the auditor to inform all employees of the results, contents of the evaluation where possible, and have the employee sign off receiving the evaluation? Response: no. Evaluator sits down with the employee and goes over the performance evaluation. Did Agent Cooper follow up, given Troy's statements that Ms. Fraley sat with him for reviews and wrote instructions on them? No. Did he ask her about Troy not sitting for reviews of his own staff? No. Bias and lack of objectivity. Worse, when we listen to the audio, which I hope we will do here today, we will hear again and again willful coaching and avoidance of logical follow-up questions on the part of Agent Cooper. For example, once it was identified that Ms. Fraley sat one-on-one with Troy for reviews and made notes on them, did Agent Cooper ask how many times that had happened? No. Did he question the strange management process where Ms. Fraley sat for reviews of the staff and not him? No. I could go on. And if we also listen to the Charles Tilbury interview, it gets worse. Beyond Agent Cooper telling Tilbury we hope to have this wrapped up in 30 days, before any interview of Troy or any affidavit from Linda, if we listen to that interview of Charles Tilbury, we hear Mr. Tilbury say at 6 minutes and 28 seconds that, and I quote, Your Honor, Troy was a special situation because of that relationship. We will also hear at 6 minutes and 43 seconds in that audio that Troy was only to have contact with Mr. Tilbury in a special management arrangement that had been put in place. But on March 18th, exactly 1 month after the AG's office received Linda Fraley's affidavit, and true to what Agent Cooper told Tilbury, Special Prosecutor Camaro made an entry in my prior affidavit claiming that there was no probable cause based on the investigation you ordered, and that's Exhibit 8. Today, Troy's attorney Gary Rosenhofer, is who suggested to me that I request the BCI audio interviews. But they did not contain something he thought they might. That at the end of the interview with Troy Bushman, at which Mr. Rosenhofer was present, Agent Cooper said that Linda Fraley was, quote, a good person and we need to clear her good name. If Agent Cooper submits the questions today, I plan to ask him about that, the incredible bias and lack of objectivity it demonstrated, and what discussions led him to that conclusion regardless of the investigation he was tasked to complete. Your Honor, on April 5th, 2018, Matthew Donahue of the AG's office told you, per the transcript of that prior hearing, these things that I want to read quickly. Mr. Donahue, I'm also under the belief that there either was or is, and there's some dispute according to counsel, an investigation by the Ohio Ethics Commission. As the court knows, the Ohio Ethics Commission operates under strict secrecy. I've spoken to the Ohio Ethics Commission, and they're limited in what they can tell me and what they can give me. However, they have indicated to me that they're going to give me any and all documents that they possess regarding this matter, but they cannot do so before the Commission's meeting on the 13th of the month. The court said, now, there was some indication in some of the literature that they had previously looked at this and ruled on it. Mr. Donahue replied, that is correct, Your Honor. The court said, did you hear that from them? Mr. Donahue replied, yes, Your Honor. That was not true. And the 13th came and went. Not only was there no such investigation or ruling, there had been no records request from Mr. Donahue to the Ethics Commission asking for those records. I pursued it and was told by the Ethics Commission that there had been no investigation or ruling whatsoever at any time. Why do I mention it here? Again, bias and lack of objectivity. 6 weeks ago, the Claremont County engineer resigned here and was convicted. That came from an auditor of state investigation and was prosecuted by the Warren County prosecutor. Within that, 14 current and former employees of the engineer's office were grand jury witnesses.
Yeah, it's sustained. That has nothing to do with this.
Okay. May I respond?
I don't want to hear any more about that. That's a totally
what has to do with
issue.
people being afraid to speak up in Claremont County? How do you think I found out about this original situation with Troy? Do you think I just found out about it on my own? It is more than past time to demonstrate that the law is to be followed, and the four corners of the affidavit are what matter. I have established more probable cause than most prosecutor filings. Now, some in this room want to distract and divert attention from the audios that I hope we listen to, that despite bias and lack of objectivity from Agent Cooper, still blow away the low bar of probable cause. Your Honor, the reason you should find probable cause is because there is probable cause. Your job is to be unbiased and impartial and look at the affidavit, the four corners of it, especially listening to the audio that's part of that affidavit. This is an important matter and is about ethics and integrity in government, and a matter kept secret for fear by those impacted. A complaint should be issued to take it out of my hands and out of your hands, and let there be criminal proceedings commenced. Please, let's listen to the Troy Bushman audio. Let's look at the review notes. If it is your pleasure, we can also listen to the Tilbury audio as well. It all makes it easy to see. ORC 102.03D reads, no public official or employee shall use or authorize the use of the authority or influence of office or employment to secure anything of value or promise or offer of anything of value that is of such character as to manifest a substantial and improper influence upon the public official or employee with respect to that person's duties. That law has not changed as far back as all these events occurred. Probable cause is a reasonable basis for believing that a crime may have been committed. I think this one is exceptionally clear, especially if we listen to the audio. I hope that the right thing gets done today.
All right, thank you, Mr. Hicks. Gentlemen, do you want to respond?
Yes, Your Honor. Brad Tamaro with the Attorney General's office. Your Honor, I'd like to start with the purpose of this hearing. The basis of this hearing, as identified, was it's a probable cause hearing. That would be pursuant to Criminal Rule 4A. That rule exclusively allows the court to examine the complainant as well as any witness the court wants to examine. The purpose recognized by the courts, and I'll cite to Metzenbaum versus Viatanio, 2002, Ohio 489. The purpose of the PC hearing, a probable cause hearing, is to permit the prosecuting authority the opportunity to discover whether probable cause to pursue a conviction exists. The fact that the recognized purpose of a probable cause hearing is to allow the prosecuting authority the opportunity to discover PC to pursue that conviction clearly indicates that it is the prosecutorial authority that is authorized to participate in that hearing beyond anything other than as a witness. Now, the complainant just stood before the court and claimed or pleaded with the court that the law is to be followed. And then he stands there and says that he plans to ask the witness, the state's witness, or any witness, questions. Well, if the law is to be followed, the courts have recognized that nothing in Criminal Rule 4A, that's the basis for this hearing, that creates the authority for this hearing, gives a complainant the right to question any witness. He has the right to be a witness. He has the right to stand before the court and explain his affidavit as he did. He has the right to answer questions. But he does not have the right to go before the court. In fact, the courts have specifically stated the hearing does not exist to afford the complainant an opportunity to press home his allegations as in the civil realm. That's not what we're here for. He is not an attorney. He is not the state's representative. He is nothing other than a person that has filed a complaint. He's a witness, and that's all. The decision whether to pursue a criminal charge is a discretionary decision that rests with the prosecutorial authority. And in this case, the prosecutorial authority is the special prosecutor. Now, a couple of points are important to relate in the exercise of that prosecutorial discretion. The affidavit that he chose to initiate this proceeding was filed pursuant to 293509 and 10. And the courts have found definitively that 293509 does not mandate the prosecution of all offenses charged by an affidavit. It simply doesn't. And 293510 does not place any duty upon the prosecutor to prosecute a misdemeanor charged by an affidavit that's filed under 293509. And that's simply because if the decision is that there's no probable cause or there's no reasonable chance of success, the prosecutorial discretion would eliminate that requirement. The decision to prosecute is discretionary, and it's not subject to judicial review, except under an abuse of discretion. The prosecutor will not be compelled to prosecute a complaint. And that's under State Ex Rel Squire v. Taft of the Ohio Supreme Court at 365. Now, in this court proceeding, the affidavit that was filed, as the complainant just identified to the court, doesn't present a matter of first impression. Looking at this complaint, Your Honor, it is the exact same complaint that was the same allegation that was the subject of the complaint that was filed by the exact same complainant. This court referred that matter to the Office of the Special Prosecutor to do an investigation. And a complete and thorough investigation was done, despite what the complainant wants to interpret that investigation to be. The results of that investigation led to the determination by the designated special prosecutor that there was not a substance, probable cause, for any further prosecution or pursuit of that case, and the matter was closed. The current matter before this court does not present the court with any new information upon which the prosecution in this case could ethically go forward. All he has done is take parts out of context and say, well, I think there's probable cause, Judge. He's not the prosecutor. He's not the one that's going to be standing in front of the court and standing in front of a jury trying to take somebody's rights away on a case that does not have probable cause. The complaint has done nothing more, again, than take parts of the state's investigation, either misrepresent them, misstate them, or take them out of context, and then ask this court to issue a warrant for arrest, which, again, the courts have definitively stated that the court is not required, when you're looking at a misdemeanor, to issue any kind of warrant. The statute in this case specifically says the court may, if it finds there's merit. But the court cannot compel a prosecution at that point. Now, as to the statement, as to some of the points that were made as far as investigation in this instance, the complainant has stated, well, Troy Bushman, in his interview, sits down and says she sat down, the auditor, sat down with him personally and conducted the evaluation. Well, that's not accurate, Your Honor. That's not accurate in that regard, and it's not accurate as to what Mr. Tilbury said.
No, I saw there was an evaluator who did that.
That's absolutely correct, Your Honor, as identified in the thing. Mr. Tilbury, in his interview, states, which was blown right by, and it's interesting that the complainant now, just before the hearing, a day or so before the hearing, suddenly submits Mr. Tilbury's interview and says, well, see, here it is. Well, he doesn't...
Well, frankly, if they were fixed, there'd be a better evaluations. His evaluations were mediocre at best.
If you look at the evaluation, if that's a favorable evaluation, I hope my boss doesn't write that on me, because I would like to continue my employment. However, whether and as that would be, Your Honor, as Your Honor just pointed out, in any kind of contested action where you're claiming, where the state would walk in there and claim that, gee, he violated, this government employee violated the ethics rules by giving a favorable evaluation to a family member, whether or not that evaluation is quote-unquote favorable is a contested issue. But I'm not even going to go there, because that's not necessary for this court's determination, or it wasn't necessary for the state's determination. There's no probable cause. Mr. Tilbury stated without qualification in the interview that the complainant is referred to, without qualification. He did the interview. He did the evaluation. The auditor had no input into it. He also states at one point in his interview that he never felt coerced to give a favorable interview by the auditor. The auditor, and again, even what the complainant states right now before this court, well, gee, he was treated in a special manner. She put in special controls. Mr. Tilbury stated, and this is what the complainant's referring to, the special controls. She's out of it. Mr. Tilbury was the supervisor. She was not to supervise at all. Mr. Tilbury was to do the evaluations. She didn't have any input. That's the special nature showing she violated some kind of rule, ethics rule. The input into it was, I'm not going to have any input. That's what the state would want. That's what the ethics rules demand. The question of it, we'll go to what the other statement was. Sat one-on-one. Well, when you listen to that tape of Mr. Bushman, he doesn't say she sat one-on-one, but he does say she sat with him, doesn't indicate that there's anybody present, and went through the evaluation. But what sort of slipped by the complainant's interpretation of that was immediately after that statement. Immediately, Bushman states, well, the evaluation was already done. He also notes that it was commonplace after that. He notes that it was commonplace, in response to questions by the state's investigator, that he wrote evaluations on his employees, and that the auditor would would, for every employee, sit down with that employee and go through it with them afterwards, after he gave the evaluations. That, by far, Your Honor, is not something that's unusual then, and it doesn't show anything he was treated any differently than any other employee or given any other consideration. Now, going to the detailed handwritten notes, Your Honor looks at those evaluation forms that were submitted. Those detailed handwritten notes are cryptic at best, and what they do state is it's in the section of the form that says employee comments observed. It doesn't say anything. There is no testimony. There was nothing in those interviews where Bushman said, well, gee, the auditor conducted the interview or the evaluation. No. He said, well, she sat back and took some notes. The employee comments observed that is identified on one form. Mr. Tilbury says he gave the evaluations. He never says in that course of any part of that interview that the auditor interjected anything, took over the interview evaluation, required anything to be done. She separated herself from the evaluation process as is required. Now, the ethics rule does not create a no relatives policy, and it doesn't create a no contact policy. It doesn't prohibit an officer of the state from discussing things with a family member. The fact that she sat down, that the auditor sat down after the evaluation was performed and talked about it with the employee that's a family member does not violate anything. Setting in on the interview, which was the evaluation conducted by Mr. Tilbury, doesn't violate the rule. She didn't participate. The fact that she wrote down his comments, his being Mr. Bushman, doesn't violate any rules. She didn't take any action based on it. Now, we also heard, which was totally irrelevant to this proceeding because there was only one complaint that's the subject of this current action, and that was, well, she performed the performance evaluations, which the evidence is directly the opposite of that. Mentioned, well, gee, she fired him. She fired Mr. Bushman. No, she didn't. The investigation disclosed that the portion of the BMV that he was working for is, and I'm going to use my kind of term, it was a contract agency. It was something that was either purchased or appointed or whatever to the auditor in this instance. She won the contract to do it. But she determined she was not renewing that contract. A new person was going to take over that section, that division of that BMV section. That person had the right to hire, fire, and do whatever they wanted to do. The auditor did not have any authority to demand or require any employee that was part of that unit that's going to be run by somebody else as their office to retain that person. All the letter does, or when the auditor informed the person, Mr. Bushman, of that, was inform him that, hey, good luck. I hope it's, and this is my paraphrasing, is the impression you get from that is, good luck in there, maybe he'll keep you, maybe you won't, but, that's going to be terminated as of this date because the new person's taking over that agency. She didn't fire him. The job went away because she decided she didn't want to continue to run that division or that unit, whatever it's called, of the BMV. That's a far cry from taking adverse action. It doesn't require the public official to expend money or expend resources or whatever to continue to operate another unit so they can continue to employ the person that they say, that the complainant says shouldn't be employed in the first instance, but which was not improper in that instance either. In this whole thing, Your Honor, in this whole thing, it comes down to, again, we'll go back to what the complaint is here, the performance evaluations. again, Mr. Tilbury, with no qualifications in his testimony or his statement to the agent, there's nothing in there contrary. States he did it. The auditor had no input. The auditor did not coerce anything. The auditor did not, nothing was changed. Missing from the complainant statement here is, after that one-on-one that was conducted after the evaluation was done, there's no indication anywhere that anything changed in that evaluation. Nothing happened. It was simply going through it with an employee as she did with other employees on their evaluations. There is absolutely no evidence that's been presented to this court that was not reviewed by the state, not ferreted out by the state's investigator, in the initial determination that there was not probable cause to proceed on the exact same complaint. The absence of any new evidence upon which the state could ethically, we're big on talking about ethics, the absence of new evidence presented by this complaint upon which the state could ethically alter the previous determination that this case, this charge, did not contain sufficient probable cause to proceed with a criminal case, puts the state in the position that it properly exercised its discretion on that first complaint. And it would be ethically bound in the exercise of its discretion in the exact same fashion based on the exact same evidence. The second time that complaint is filed, the third time that same complaint is filed, the fourth time that same complaint is filed, when there is not a scintilla of new evidence upon which the state could ethically make a change of its prosecutorial determination. Your Honor, the state does not believe that this action, and I'm not going to address the potential reasons from the pleadings that have been filed in this case, though the state would identify that since the complainant is in nothing more than a position of a witness, that any motions that have been filed by the complainant, such as an intention to use evidence or response to object, any kind of thing that was filed directly in relation to this should be stricken from the record, because the complainant has no right to file those. He had the right to file the complaint, but he's not a prosecutorial authority. He's not a party to the action, and he has no right to file anything outside of the complaint and his support for his supporting documentation for that complaint. And the state would ask this court to quash any subpoenas that have been issued, since he has no right to issue subpoenas, and to strike any such documents that he's filed from the court record, with the exception of the complaint and the documentation that was supported or submitted in support of that affidavit. Thank you, Your Honor.
Thank you. Would you care to speak also, Counsel?
Yes, Your Honor. Thank you. Christopher McDowell. I am Ms. Fraley's attorney, Your Honor. Your Honor, I feel like we are here to plow the same field that we've already plowed. In the first complaints in March 20th, 2018, filed by Mr. Hicks, he makes this allegation: as described fully above, Claremont County Auditor Linda Fraley, as a public official, knowingly authorized and employed the authority and influence of her office to secure the continued employment, review, and termination of her stepson, Troy Bushman. That's the first. That was a year ago. And attached to the affidavit initially were the evaluations that he's reattached here today. The complaints today reads, as described more fully above, same sort of language, Claremont County Auditor Linda Fraley, as a public official, knowingly participated in the evaluations of her then stepson, Troy Bushman, and used the authority and influence of her public office to secure the continued employment, his continued employment. That is the same allegation. It's the same allegation. And pursuant to the initial allegation in 2018, the special prosecutor, this wasn't Claremont County prosecutor, these were not Claremont County judges, the special prosecutor in the case ordered and had BCI conduct an investigation, a thorough investigation that included interviewing of witnesses, Mr. Bushman himself, and Mr. Bushman's superior, his supervisor, Mr. Tilbury. And all of that information has now just been packaged in a new package with a new bow by Mr. Hicks and brought again. That is, there is nothing new under the sun here. All the exhibits, all the information was considered by the special prosecutor previously, pursuant to his complaint in 2018. And I am in the unique position in this case of having a prosecutor who is eloquently arguing against my client's prosecution. And he has even indicated that it would be unethical to prosecute my client. That is, that they have already made a determination on this evidence. They made the determination that my client, that there's no probable cause to believe that she committed a crime. And so if the case were to go forward, I would just play everything you just said. But it won't go forward because they've already made a determination once. Mr. Hicks should not be permitted to drag everyone into this court time and time again to play the same song. We've all heard this. We've all heard this music. We've all decided that we're not going to dance to his tune. But he believes that the investigation by BCI, that this honorable court and the special prosecutor are involved in a conspiracy. He said that this honorable court whitewashed the last proceeding. He accused Your Honor of committing a crime. He accuses the BCI investigator who's sitting in the back of the courtroom of intentionally skewing the investigation. There's conspiracy theories all over the place. But, Your Honor, we all believe in the American judicial system. We all believe in the prosecution and the proper investigation of cases in this country. The special prosecutor's from Columbus, from the Attorney General's office. The investigator is not from Claremont County. He's not from the Claremont County Sheriff's Office. He's not from the police here. He's from BCI. He has no dog in this fight. He conducted a fair and impartial interview of the witnesses. And he provided those tapes, the tapes that Mr. Hicks wishes to play in court, he provided those tapes to the special prosecutor. After listening to the tapes, the special prosecutor determined that there was no probable cause to move forward. Why are we here? We are here because this is a personal vendetta on the part of Mr. Hicks. I filed a Rule 11 motion. I believe that Mr. Hicks should be sanctioned. I won't speak on that right now because I'm speaking on the other issue, but I'd be glad to. I think that this court, as the prosecutor indicated, needs to look behind who the complainant is to determine the veracity of the complaint. If you recall, the last time we were here, he was in a political fight with my client. They were going for the same office, county auditor on the Republican ticket, and he filed the complaint to coincide with early voting. So he just refiled it. He wants to embarrass my client. He wants to try to raise himself up by bringing other people down. He's asking Your Honor to have my client handcuffed and taken to the Claremont County Jail. And this isn't the only case. The day he filed this case, he filed 2 other cases against 2 other of his political opponents. I asked the clerk of courts, how many of these cases have been filed in Claremont County in the last 5 years?
Can I object to this?
He said 4. All 4 of them were by Mr. Hicks. This is an abusive process. It's frivolous and vexatious litigation. And I hope this court will dispense of it quickly. Thank you, Your Honor.
Thank you. Thank you. All right. I've heard everyone present their side of it. I do agree that this is basically the same case that I decided back before the election. Mr. Hicks, I found that there was no basis for what you filed. But even there, it went on to the Attorney General and the Special Prosecutor, and they did a very thorough investigation and found nothing. Now, that was during a campaign. You were running against Ms. Fraley in the primary. So there's probably a little more wiggle room during a campaign as about what you can do. But that campaign is over, and you've lost. Now you come back with basically the same thing here, trying to embarrass her or embarrass other people. So I'm turning down. Your motion is overruled. Just please be seated and listen for a minute. Your motion is overruled. And I'm going to grant sanctions The only issue is what will the sanctions be. So do you want to speak as to what they might be?
Yes, Your Honor. Thank you, Your Honor.
Yes.
Your Honor, as Mr. Hicks does appropriately point out, I did ask for the dismissal of the case. We can't do that. Mr. Hicks?
Yeah, be seated, Mr. Hicks.
I'm not allowed to comment on the sanction.
You can have a comment as soon as we hear from you.
I feel that an appropriate sanction in this case would be attorney's fees. My client has had to endure attorney's fees and turmoil as a result of this. I think that would send a message to Mr. Hicks that there is a financial price to pay for this. I could file an affidavit with the court as to what my fees have been up to this point, and the court could rule on the appropriateness of those. I feel that would act as an adequate deterrent to Mr. Hicks for filing frivolous and vexatious litigation. Your Honor, and I feel it is entirely appropriate.
Okay, I wish you would do that and file it, and then it will be submitted to me for review.
Yes, Your Honor.
And I'll go ahead. Mr. Hicks, you want to speak to sanctions? And stick with sanctions. I don't want to hear about the case again.
What may I ask you, just, Your Honor, have you actually listened to the audio?
I have.
Okay.
Let's not get into the case again. That's
Okay,
over.
I just wanted to make sure that you've listened to both audios.
Do you want to speak to the sanctions?
I'm going to speak to the sanctions, yes,
All right,
sir.
let's hear it.
First off, I don't know how sanctions apply in this situation. Okay, sanctions, as
Well, that's
far
up
as
to
I
me. If
understand,
you're
is
a
civil.
vexatious litigator, which I think you are, well, you ask a question and I'm answering.
I didn't finish my question.
Go ahead.
Okay. So this is part of the criminal procedure. This is part of the criminal procedure. Sanctions are a civil thing. Okay. We've heard again and again that the complaint was the same, that my affidavit was the same. But my affidavit included key new information, which was the result of the investigatory process.
Okay, you're getting into the facts of the case, and I've already determined all that. If you want to speak to the sanctions, now do so. Otherwise, please
I'm just
have a
speaking
seat.
to the sanctions that I find no basis for sanctions on a criminal procedure, such as what's going on here. If there was no merit to my filing, then these people don't even need to be here, because Your Honor would have simply looked at it and said, refer it, it's done again. Okay, but we're here. A hearing was scheduled. There's been a lot of time put in by Mr. McDowell in writing documents that have nothing to do with the four corners of the actual affidavit, but instead are filings meant to demonize me. Now he sits here in something that falls under criminal procedure, saying that there should be civil sanctions that is not part of criminal procedure for filings done by Mr. McDowell that have nothing to do with the four corners of the affidavit, but rather are written more like editorial columns in newspapers about Chris Hicks. So, Your Honor, I would question whether sanctions are even a legitimate option here in this particular case. So I'd ask Your Honor to please review case law and other law to make sure that this is an appropriate response by the court. We had one other situation where an improper response by the court ended up with an overturn on appeal. Let's try to not have that happen again.
All right, thank you. I appreciate the warning.
Thank you, sir. Maybe perhaps a belt and suspenders approach might be appropriate. That is, I find his conduct to be contemptuous of the court. His comments made after the last proceeding that the court was whitewashing matters to be contemptuous conduct in vexatious litigation. So I think that out of an abundance of caution, I believe Mr. Hicks has argued that the filing of an affidavit is a civil action, a criminal action that's not commenced until the matter is turned over to the prosecution. But as a belt and suspenders approach, if the court perhaps would say that...
You might want to include some of that language in your response to sanctions.
Yes, sir. Thank you.
Okay. All right. Thank you. Gentlemen, that concludes today's matter. The only thing left is for me to determine sanctions.
Yes, sir.
All right. Thank you very much.
Thank you, Your Honor.
All rise. One more county minutes, full court is in recess.